Can you all hear me out there? I usually don't have any problem with that, but I always have to ask.
Just pull that up a little bit, Terry. Power right there. There you go.
How about that? Okay.
Fun is your friend.
I want to start out by acknowledging my boss, Director of Natural Resource Management, Christine Lee, who's here with me today, over here in the corner, and Scott Harris with the regional office as well from the Intermountain region, who's sitting right next to her. And I'd like to make also acknowledgement to some discussion yesterday, of which I think there were a couple of speakers alluded to the fact that there are some state and federal land managers that would ordinarily be here and are precluded from participating and speaking. I'm here today as a direct result of Director Lee, our regional forester, Nora Razier, and Chris Iverson, in our philosophy in the Intermountain region of the Forest Service, that we're working partners on the land. That needs to be demonstrated by involvement and contribution anywhere and every place that's possible. So we don't shy away when you invite us, and I do want to emphasize we consider this a great honor that you would ask us here today. I don't think it's any secret that there are probably some out there that think that hiring some of us was like losing 20 good hands. But I hope to change that temperance a little bit by the time I'm done speaking today. So it's a great honor to be here. I thank Todd McFarland and Protect the Harvest. I think this is the start of something really beneficial for the industry and agriculture, and I hope we can continue our partnership as we move forward. I'd like to tell you a little bit about myself. I have well over 40 years of experience in ranching and public land management. Ordinarily I wouldn't get it this far into the weeds with my history, but since it appears that a big part of this organization is America and what it represents, I stand before you as a prime example of immigrants that have come to this country through the Spanish conquistadors, who worked their way up through migratory sheep grazing and agriculture and mining to establishment of ranches and ranching. And I've worked my way from my grandfather's good and my father's good efforts towards public land management. So I can promise you I do know the front end of the back end of a cow, and I proudly take that knowledge and that background with me in the advocacy of my program and the disposition of my job in the federal government. I'd also like to acknowledge that I represent hundreds of hardworking federal rangeland managers who on our worst day come to work and swing away and make many mistakes and accomplish many great things. But we're here as your working partners, and I'll talk more about that as well. I'm proud to ride for the Shield and represent the U.S. Forest Service. So yeah, there was a lot of dust up about me being here today, and I just want you to acknowledge that it was some heavy lifting, but we feel it's well worth it in the Intermountain region. A couple of provisos, and we've heard many of them because we've had a lot of legal presentations here. With all due respect to the Hage family, I'm representing agencies that's at litigation with their family, so I hope you'll understand I'm precluded from any discourse and opinions or anything about the Hage case in Nevada. As far as the Forest Service is concerned, that's just a resolute that we have in the federal agency. And I'm also want to acknowledge that I'm not here to represent the Forest Service and make a case for federal management, continued federal management against the many efforts out there, some coming from you and some coming from your constituents, against states' rights advocacy and ongoing actions on states' rights and federal agency reduction. We in the Forest Service recognize the legitimacy of those. We don't take opinion on those. Our job is to implement Congress's will and the administration's will and work as best we can with you as federal partners going forward. But having said that, I do think, and you'll get some great presentation from Angus McIntosh, whose presentations I've seen, and I think he makes a very eloquent case for past appropriations, and he's a great, obviously a great historian of all that, very knowledgeable. And then you'll get a presentation following mine that'll probably give another perspective. So I think the way forward is the place it's always been, and that is implementing the working partnership out there on at least our National Forest System lands. That's been our credo. That's how we roll. We have some tenets in the Intermountain region. We view our National Forest System lands as working landscapes. We have a tenet to resolve as best we can conflict issues at the ground level with locals that have the knowledge to resolve those issues. We want to build a trusting relationship. Any good partnership, and if you're a rancher, you understand partnerships, has got to come from a basis of trust. And while we change the laws, and we have great discourse about the laws, we've got to remember to work within the laws. And I'll talk a little bit about that going forward. We'll get to that. Ranching's all about adaptive management, and that's certainly, I think, the way forward. Learn, adjust, implement. And then I'll talk a little bit about some of our changed conditions. States' rights issues are one of a huge list of challenges that we face in the Intermountain region in the West. This is a new West. It's been an evolving West over the past several decades, and that presents, no matter what side you come from, many challenges. Sir, let me get to it and I'll explain it. So before we go forward, just let me do just a short chronology of how we got here, at least with federal land management. And I want to acknowledge that there could be plenty of debate about the efficacy of these decisions that were made in the past and acts and laws that were passed. But it is how we got here with the federal agencies and where our imperatives come from. As many of you know, I'm looking over here at Angus. No one knows more than him. We have and I've just done a brief chronology here. We had Western territories established in the early to mid 1800s in this very state. The Utah Territory was established around 1850. We had a great land disposition effort with then our Congress and the United States government. Through many efforts, one of the most significant ones is the Homestead Act, to go out with manifest destiny and settle the West and establish commerce, and that went on from 1862 to 1976. When Utah became a state, Utah signed into the Utah State Enabling Act, 1894. And acknowledged at that time deference to the federal government of all preceding laws, rights, and appropriations. And then in 1905, with the establishment of the forest reserves, which really is the precursor for U.S. Forest Service management in the West. The Secretary of Agriculture was given authorities to establish and regulate the forest reserves. And then lastly, probably the most significant legislation, and there have been many, Federal Land Policy Act of 1976 further validated that and set other terms and conditions relative to land management. And again, as I'm working through this, I want to acknowledge that there is contention with how these were done, decisions that were made. I'm just trying to establish where the federal agencies, and particularly the Forest Service, got our anchor points. So a significant part of the authority given to the Secretary of Agriculture basically did the following. It authorized to issue instructions and set regulations for the management of the forage reserves and the land and the occupancies thereof. And the first regulatory book was established in 1905 with the famous Forest Service Use Handbook, and that was the very first direction and guidance that our forest rangers at the time in the Forest Service used to go forward with our management. So I think we can all agree that there's conflict and there's difference opinions out there about prior appropriation and rights. And they don't stop at just land ownership. Certainly, probably one of the most significant issues is Western water law, first in time, first in right appropriations. What's significant about the Intermountain region, by the way, the largest grazing region in the U.S. Forest Service is in this region, within the 5 states that we manage. The biggest ranches in the United States, a lot of people don't realize this, reside in this region. Biggest grazing program, the biggest wild horse and burro management imperative in the United States Forest Service resides in the Intermountain region. And one of the significant things about this region, if everyone, and many of you know this, a lot of parts of the country, ranches over the course of time have changed hands. That's just an evolution of Western ranching. But what's particularly significant about this and this region in the state of Utah is a lot of our ranches in this region were established before the forest reserves. I'm looking over here at Stanton Gleaves. I don't know this for a fact, but I think his ranch may fit that mold. Certainly the Hages do. And folks that established those ranches and their descendants have a particular tie to the land that I think is uncommon in other regions that I've worked at in the western United States and the U.S. Forest Service. And my career spans working in Washington, D.C., all the way to Colorado and New Mexico, and as I said, ranching. So we acknowledge that in this region. We acknowledge that culture and the significance in that culture in our management approach. Our credo is caring for the land and serving the people, and we do the best we can with that. So the key provisions of establishment of the forage reserves, and these were validated by the Utah State Attorney General's office in a meeting we had about a month or so ago in Richfield, Utah, is it gave authority and direction to the Secretary of Agriculture and as delegated to the Chief of the Forest Service to establish grazing allotments, set grazing occupancy limits, regulate grazing use, provide and set grazing fees and permits, and establish grazing use as a special occupancy privilege. One of the key contentions of the West is the idea of grazing rights versus grazing privilege. While we can all debate that as we move forward, it's clear that the federal laws basically identify that Our permits are grazing privileges. They're revocable license. They do not represent a right. I would say they're a special revocable license. We issue 10-year grazing permits to our permittees. The only way you lose those permits is if you waive them away with preference or without preference. You lose them through some non-compliance action, or you just give them up and walk away from them. And you'll hear in a little bit from me a strong recommendation to not do that. So while all this theater and drama goes on around us, and we can argue our differences on rights versus privileges and these congressional laws, I would submit to you one common ground that we have. We've got ranches to manage and permits to implement. We got the largest, over 1,700 permits in this region that ranchers heavily depend on in the Intermountain region for their livelihood. And they've got those ranches associated with those permits. And one of the key features of this of ranching in the Great Basin is mitigating that forage bottleneck that comes in the winter when you got to feed cattle. And so you got to have cattle on the land to grow hay, not only to sell hay, but to feed hay in the winter. So it's a big deal in this region. So we got work to do. And part of that work is cooperating together to meet national forest objectives. Some of the benefits of our cooperative work are by keeping ranches on the land, we sustain open space, which is vital to a changing country, and particularly in the West. It's very important to these small communities we have in our regions and what I call the working circle. So many of our small communities from Wyoming to Idaho to Utah to Nevada evolve around the culture of ranching and grazing, and they're significant. Whatever that contribution is, it's significant to those communities and the culture and the fabric of those communities. And a big imperative with the Forest Service is supporting the industry through our work, our partnership. I talked a little bit about the challenge of the Intermountain region, and here in our region resides the theater of public land management. Unlike any other region in the United States, and I would include the BLM with this, we've got every issue there is within the 5 states of this region. Species conservation and viability, be it bighorn sheep, be it sage grouse, be it anadromous fisheries, be it wolf management and grizzly bear listing, we've got them in this region. And we've got a lot of environmental stakeholders that have moved into this region, 6 to 8 by my count, headquartered now, because this is where the battle is being waged and fought. Stock water, the biggest, most valuable resource we manage out there, contrary to a lot of people's belief, is not gold in the mountains, it's not oil, it's water. That is everything in this region. And right now, a big contention with recognizing federal agencies as beneficial users and the holder of stock of water rights is going to become a huge challenge as we move forward. Before I retire, we will see a significant lawsuit against the Forest Service on issuance of grazing permits because we don't hold water rights. And if you don't hold a water right, how can you be issuing a permit? Because you need water to manage public land grazing. And I'm not talking about vested water rights, which you all established and had under your own right and ownership long before the forage reserves are established. I'm talking about development of new water that needs to occur out there to allow us to manage together, to mitigate issues, and to keep grazing on the land. We've got an amazing component of stray livestock. and unauthorized use. When the economy tanked a few years ago, probably a lot of people don't realize this, we got a lot of free grazing that popped up on the National Forest Service lands. Dealing with that unauthorized use, dealing with that stray livestock has brought with its own contention and litigation. It's a heavy lift to deal with that. And then stakeholder relationships. As things have got Western, as I call it, as we call it, in the West, passions have risen to the future, have risen to the surface, and it's been hard for us to manage together when we're always, and I shouldn't say always, but it seems like increasing over the last decade or so at loggerheads with each other. Because when we're working against each other, we're working for those that want to eliminate public land grazing. That's just a fact out there. We got a lot of young folks that Christine and I hire that we've put in the West, and they're in Tonopah, Nevada, and they're in Beaver, Utah, and they're up in Grays River, Wyoming, and they're out there and they're learning their craft, and they're working with ranchers right now. They're learning about public land ranching and why ranchers do what they do and why their permits are configured, and they're trying to work with ranchers and teach how we monitor and what those standards are, and they're working together. But we've also got a lot of intimidation and push out there, in my opinion, large part from folks that aren't even those that hold grazing permits. And it's making it more difficult for us to work together. And we're dealing with that, but it's becoming tough. And then the New West. Here's just in. We've got a change in demographic in the West. A lot of folks have moved in. You can now live in Utah and your business can be in Minnesota. And what brings with that is a change in public land values. Folks that don't see things the way we see them in the West, the way my dad raised me, the way we ran our ranch, and why we did what we did is not as understood as it used to be. So we've got a public education issue in front of us, and we need to do that as a partnership. So while we work through this theater, and we've started to get a lot of protests and issues in front of us, I've got some proposals that I'm sharing with all of our permittees, our partners out there. We tried to emphasize those. The Utah State Attorney General emphasized those about a month ago in our meeting in Richfield, which Todd was there with me. Your grazing permit is extremely valuable. Now, why through regulation we don't recognize the value of an agency grazing permit, I will guarantee you that those grazing permits are extremely valuable. They're assets on the market, and you should not let go of those lightly. We recognize that. So don't let your permits expire. Manage your permits. We're under the Rescissions Act of 1999, and then there's been several appropriations that follow that, and we're directed by Congress to reissue grazing permits to term grazing permit holders under same terms and conditions, and we do that very well. But every time in this litigious environment that we're in, one of those permits expires, either through the fault of our own managers not being vigilant on the job, or you as permit holders reissuing those permits and getting them re-signed becomes a heavy lift, an unnecessarily huge heavy lift. Don't let those permits expire. Don't waive your permit under protest. I said before, that permit's yours unless you give it up. We fully acknowledge the passions of the day, and it's not our role and our job to get in the way of folks that might want to express their opinion. So what I'll tell you is burning your grazing permit or burying your grazing permit doesn't you don't lose your grazing permit in the Forest Service over that. A few months ago, when we had some of this dust up over protests, I got a lot of calls from newspapers. What are you going to do now that these guys and these women are giving up their grazing permit? I'm going to go to the printer, and I'm going to the copy machine, and I'm going to print another one out, and I'm going to approach that permittee, and as will all of our line officers, and we're going to go, here, you lost something. Let's go back to work. We have 3 copies of a grazing permit. It's signed by the permittee. We honor that permit. For those that get the idea that they're going to go on without paying their grazing fee before they stock the allotments, before they pay their grazing fee, we're going to wrap our arm around you, and we're going to go, and we're going to help you pay your grazing fee. We don't want to see ranchers get into trouble over that protest. You've got a lot of opportunity to change laws and regulations and make a good case, but it makes it tough for you when you're outside the law while you're trying to do it. So that's another piece of advice we give our permittees. And I always advocate to our people in the field, partnership above all else. Work with your folks at the field level. I'm not saying we're always right. As I travel our region, I run across many instances where we've made some bad calls. We've got a process for elevating those calls up and dealing with them and correcting them. But it's better done at the ground level and within the region than going outside. And as much as I respect the practice of law and the law background, because I come from it, I'd much rather see you keep money in your pocket and let's resolve issues on the ground than see a bunch of attorneys get rich at your expense or the public taxpayer's expense. Adversarial relationships don't help us. Let's deal with it. Let's face each other up. Let's do it in a productive, responsible way. We're managing these uses of these landscapes for multiple use. I will guarantee you I know this region well in our grazing allotments in this region. We could triple up the grazing capacity in this region today. One of the reasons we don't is these lands and our imperatives are multiple resource management. So there's other uses, other values, other objectives out there besides me doing what my dad would have liked and increasing our herd complement fourfold. Now, until that changes and we get that direction from Congress, from whatever discourse is engaged, that's got to be the way we roll. So let's work together to maximize what that can be and to be as relevant as we can be with public land grazing, because we in the Intermountain region do believe that the most valuable grazing vegetation management tool we've got, the most efficient, is public land grazing with livestock. So this year, Christine and I want to leave with you a couple of Faqs and challenges that we face. We held as much as is our allocation to probably 6 national forests off the top to cover litigation costs. Every decision we make, I don't care whether it's to put up a fence, it's to develop just a minor stock water development, it's to authorize a grazing use in this region, is appealed and litigated. That's what we've evolved to, every one of them. I can't tell you the millions of dollars that have gone into litigation, whether we sought it or not, with in our grazing program. We got the largest wild horse and burro program, as I mentioned previously, in this region, and we got a herd of horses out of control, absolutely escalating out of control. And one of the things that Christine and I advocate for, it's wrong to take a Forest Service rancher down in capacity while those horses aren't being managed. We've got to find a way to manage these horses, and I wholeheartedly agree with some of the presentations that were made yesterday about that. They'll tell you there's subterranean grazing going on out there with those horses. I'm as big a horse lover as anybody in the West, and so is Christine. But we're not doing the elk, the deer, and the fish any favors. We've got a wild cattle herd in Nevada that's building. It's well over 100, probably well over 200 now, running fishermen out of riparian areas. It's been out there for a long time. We've got to deal with that. In Idaho, I had a rodeo manager dump 27 rodeo bulls out on the forest. We actually had some hunters knocked off their horse and pelvises cracked and everything else before we could get them off the land. There's a lot of things going on out there for us to deal with, let alone us being at loggerheads with each other. So I guess I'm looking at you, Ramona Hage, and I want to see you stay on the land. I want to see you guys have a permit. You got a long history with us, as we do all the permittees that happen to be the Forest Service in this room. But there's contentions there, and a lot of them aren't our fault. They come upon us, they come upon you. But whether you like it or not, until these laws are changed, we've got to find a way to work together and work through that working partnership. So I'm going to be here and obviously take questions now, and I guess there's a panel right after this. I promise you, I'm a straight talker. I'll take any question and issue you got. There was a gentleman that was just here that wanted to explore me a little bit. I'm here to face it up.
I think you can change your bio, Terry, and you can say better than coffee. Because I believe you got the juices flowing better than coffee. I got one question. You said that 6 to 8 environmental stakeholders had set up shop in this region. Who are you talking about exactly?
Well, I don't want to call them out, and I've already been dressed down for sharing names, but
I don't need the name.
I'll be glad.
What type of stakeholders are you talking about? Are you talking about the pseudo-environmental groups?
They bring their loyal appellants.
Yeah, John DeWardy, Modesto, California. A large problem that landowners and farmers and ranchers have with agencies is the lack of due process and lack of appeal process within the agency for decisions made by field staff. I've had a personal experience where the field staff wasn't aware of internal guidance documents once in deposition, wasn't aware of interagency memorandums of understanding. This is all through deposition. It's not hearsay or casual. And recently we had the Sackett case, which came down 9-0 in the Supreme Court, that reflected the agency can't simply impugn a landowner with a bunch of requirements without any kind of a process. Since the Sackett case, and since a lot of these issues have been stirred around the issue of due process, has your agency set up any guidelines or new protocols for offering landowners due process within the agency and within its appeals processes so as to avoid lawsuits?
Thank you for that question. So the question basically, if I can paraphrase that, is one that we've been addressing recently. We can't expect the average citizen and even our permittees to understand the sophistication of many of our laws and the regulatory appeals and litigation processes that go with them. Quite frankly, that's an imperative that we have in the Forest Service, is to do a better job of educating our permittees and our citizens on those. We do a really good effort, I think, with the broad public, but not so much with special use holders. I will tell you that in this region, just this year, we reversed, I think, Christine, 3 forest supervisor decisions, in large part procedural errors, and in large part because that background wasn't well understood. This is before that ever got to litigation. So your point is well taken. We've got to do a better job of that, and yes, that's an issue.
Hi, I'm Erin Maupin, and I do appreciate you being here. That you were invited, and a lot of other people didn't make it, and I appreciate that. But you talk about, and the BLM and Forest Service talks about partnerships, And I believe that, and I can't really speak for you here, I'm from Oregon and we have a BLM permit, or allotment. And you talk about collaboration and partnership, and I do believe that as ranchers for the last 30 years, we've done everything to collaborate, to partner, and along with environmental groups. And the thing that I always come away with is that we're the only ones that are giving anything. And I understand what you're saying about you get litigated by these environmental groups no matter what you do, pseudo-environmental groups, no matter what you do, and the access to EJA funds and all of that stuff. Saying that, there won't be that many of us left out on the landscape to cooperate or partner with in a short period of time, especially with the sage grouse issue. And what would your suggestion be that how would we change what has been going on as far as with the environmentalists litigating and us losing our numbers, our AUMs, and continuing to give and give and give until there's no more to give. And there won't be ranchers on the landscape, at least family farms, in a very short order.
I'm glad my father's not here to listen to me answer your question. Here's what I would suggest, and I know it's going to sound bureaucratic, and I hate being bureaucratic. What you're saying is right. We have a lot of, I'm calling the working partners like yourself, that have maxed out. You're giving everything you can possibly give. The only thing I can say, and I often say to our permittees, is work with us so we can make the strongest decisions we can out there and bring the best analysis to bear to support those decisions. And I have every hope that we'll be defensible in those. But it's a heavy lift, and folks are wearing down. And it's not a good answer because some of these folks can bring millions of dollars. And one of the problems with federal management is, I'll give you a classic case. We won a case a year ago as strong as I've ever seen us win a case on every merit, every issue. We still ended up paying plaintiff's attorneys $37,000 of taxpayers' money, and we basically won that case. So it's a grind and it's a heavy lift, and all I can say is we got to just work together, because what's the alternative? We either walk away or we work together, and try to work together to get the best decision we can out there. Through our partnership and analysis, that expertise that public land ranchers have on how to mitigate things and graze is invaluable, especially in the new workforce that I manage. We got folks from all parts of the country. I used to be able to throw a rock and hit a ranch kid that would come to work for us. That's not the case anymore. So the importance of a rancher that'll work with us and bring that expertise to bear in our grazing prescriptions is huge.
Right here, Terry.
Yeah, Tim Smith from Harney County. I heard you basically concede that allotments are assets to the ranchers. And with that being said, we also understand in the marketplace that an allotment is a real value when a ranch changes hands. They get compensated very heavily. Sometimes the allotments are worth more than the actual fee ground that's sold. That being said, also, it seems to me like that I would like to have your opinion on this. A standing AUM allotment number, if it's reduced during that period of that active permit on that allotment, is that a take from that rancher?
The question is a reduction a financial take?
No, not a financial take. It would be determined a financial take if it went through due process and there was compensation made for that, in my mind. Is it a take of a right from that rancher if that allotment is reduced in numbers?
Not under our current authority. So we don't recognize the grazing permit as a right, and so you get a reduction. That wouldn't translate into a take relative to a right.
How does that affect the real property value of that allotment and next sale?
Big time.
Wouldn't that be a take financially?
Well, to you, to my dad, that would be a take. I said before, we don't recognize intrinsically a value in a grazing permit because it's a privilege and it's a revocable license. On the market, through LLCs, through trusts, through all of the financial configurations of which ranchers qualify to hold a permit, that's a bona fide, definite, real property asset. And so I'm not going to stand up here and deny that fact. So there's the bureaucratic regulatory answer, and there's the answer I'm giving you about the real world. So if you go to waive your permit with preference, that is going to be come into bear definitely on the value of your sale. When you go in to get a loan, and I hold a coordination meeting annually as much as I can with Farm Bureau Credit Association, all the lending associations, as part of our working partnership to work and our imperatives to keep ranchers out there, I'll guarantee you they loan on capacity of that permit as well as the permit. The biggest share of the value of the permit is holding the permit, not necessarily the occupancy of that permit. The fact that you have a permit is real intrinsic value.
Next question.
Terry, could you please?
Ronnie Sylvester.
Oh, thank you. Terry, you mentioned the grazing fees earlier. Could you please explain the range management fund and if those state collections of those grazing fees are ever commingled with federal? And has there ever been an audit of the range management fund?
Yeah, the question is resolves around grazing receipts and the management of grazing receipts, and thank you for that question. So let me take you through the fiscal history here. The receipts, grazing receipts obtained through your payment of your grazing fees are managed under the Public Resource PRIA Act, Public Resource something Act. It created the Range Betterment Fund. That fund is expressly for reinvestment of grazing fees into public land range betterment projects. So under the federal authorities of Congress, 50% of those fees generated go into the U.S. Treasury for the Forest Service, and 50% come back to the regions of which they are generated. And then Christine and I have the prerogative to reallocate that 50% back into the district units of which they were generated, or the regional forester has the prerogative to take 50% of that 50 and shift it based on regional need where range betterment projects happen to be a priority. And I'll tell you an example of one. When we get these western land fires and we get range improvements burn up, sometimes we'll make a shift of those range betterment dollars to cover reestablishment of those improvements so we can restock those allotments in a time-dependent manner. So 50% back through range betterment funds. Under our authorities, we're only allowed to take 6% of those for overhead fees for the federal government. The rest all have to go into ground betterment projects. So the other question is there an audit? I conduct a range betterment audit on our forests annually, and then periodically we have a national program audit for the range betterment fees that we conduct and evaluate as well.
Next question.
Actually, it's a statement, a short question which you can answer, and then after that, another question with more detail. First, you heard the question early on in your presentation that you were complying with laws, and you were asked, well, what laws? And I would offer this as a statement, and you can argue against it if you'd like, that you're talking about regulations and you're talking about rules more than you're talking about laws that you're complying with. there aren't that many laws really for the Forest Service. There are a lot of regulations that you guys have promulgated yourselves and have now become regulation. My question is, you're familiar with the case of U.S. v. New Mexico, is that correct?
That's correct.
Could we have your position here today on whether or not the Forest Service intends to comply with that law?
Okay. Boy, you're going to, as much as I hate being bureaucratic, you're going to push me to be a little bureaucratic here. So I'm not going to comment and give you my interpretation on another region, that's the Southwest region, on how they're dealing with that. I'll guarantee I have one, but I'm not going to give one here today. I will talk a little bit about your point about regulations. Yes, relative to governance, we have few acts that actually cover our management, and we do have a lot of regulations through Forest Service manuals and handbooks that have been given the authorization through those acts to develop regulatory processes to implement the acts. So if you stack the volume up, a lot of regulations and direction out of handbooks, fewer number of acts and authorities. So Code of Federal Regulation, APA, the Administrative Procedures Act, those kind of acts cover a lot of our permit management.
And just to follow up, because I don't know that that was clear, and I'll push you a little bit on your bureaucratic answer. U.S. v. New Mexico is a United States Supreme Court case. It applies across the country. So my question is the Forest Service in this region and any of the rest of the regions going to comply when it comes to Western water law with that decision from the United States Supreme Court?
Well, I think we are complying, but let me offer this. Let's talk about the specifics, and I'll get back to you with an answer specifically
Terry,
about whether we are.
Terry, into the microphone.
Sorry, the mic is my friend.
Yeah, see, at least one attorney listens.
I want to make sure I do your question justice. So let's get together. I'll answer your question in specific, and then we can make that answer available to everyone as part of our proceedings here today.
Okay, next one.
Thank you for being here. Callie Hendrickson from Colorado. I understand the different levels that you deal with. I work for a conservation district, and I'd like to have your thoughts on the development of local land use plans and how that can or may not be able to help you as the managers that are, down at the local level. Will those be of any value to you as local governments, conservation districts or counties, develop those land use plans? Will those be of value to you to really do good management on the land versus having stuff roll downhill from Washington, D.C.?
Question resides around the value of local land use planning and decisions made, and are they value to Forest Service management? And the answer is yes. So we're required to consider all laws, applicable laws, state or federal, in consideration of our decision making. Now, some of those we may not recognize or we may not implement, but we are required to consider those. So, yes, they are valuable. I'll give you an example. We had a case, we've got a situation in Wyoming when we were trying to develop our management plans for bighorn sheep. State passed a legislation that they would of Wyoming, that they would shoot off a bighorn sheep herd if we recognized that and permits were terminated as a result of bighorn sheep viability considerations. We worked with the state, determined in working with the state, worked with their state bighorn sheep management plan and considered that legislation as well as the situation on the land in coming together with that co-opted federal to state plan. I anticipate, since you are an expert in wild horses, that especially in southern Utah, Christine and I are getting a lot of push with wild horses that if we don't start managing those horses, we're going to have a lot of county and state laws and decisions passed to consider. And those will definitely come into bear.
Terry, we got to roll. I am going to ask you one question that could be a yes or no just to close it out. You said that we are partners on the land. In another statement, you said that we do the best job that we can. Knowing the sentiments and the passion that you brought from your father, would your father agree that you're doing the best job managing the resource you possibly could?
Boy, that's the toughest
Was
question.
it a yes or no?
I would hope he would say yes, and most of the time he says yes, but I guarantee you there's a few times he says hell no.
Terry Padilla, folks, thank him for coming and bringing forth his ideas.